Hello, Moses here. Now, it's something for you to think about and possibly answer before this video ends. On 6th May, Jen sends a letter to Grace offering to work as a freelance consultant on Grace's project for a fixed fee. In her letter, Jen states that the offer is valid for 1 week, after which the offer may be subject to revision or withdrawal as appropriate. Okay, so first of all, which kind of offer is that? Now, in this video, we're going to look at offers and what they are not. This video is part of a more detailed course, okay, on managing contractual risks that you can access through either the link in the video description or through a link sent to you via your email. Now remember, this course, okay, this program, Managing Contractual Risk, is not really about contract law. I mean, it is about contract law, but not necessarily the basics of the contract law, because I already have a series of videos on that which you can access. But the idea here is just to make you understand that if you get into a contract, there are certain problems that you're likely to encounter, and how are you going to handle those contracts. In fact, here's what typically happens when you get into a contract. Party A makes an offer to Party B, and if Party B accepts the offer, then these two parties have an agreement. Now remember, it's an agreement, not a contract, because if I say that I want to buy your phone and then you are okay selling me that phone, nothing has really happened. You just have an agreement, okay? Yeah, I'm agreeing to buy your phone and you're agreeing to sell me that phone. So it's not like if I've given you money or you've given me the phone. We have an agreement. Of course, there are things like consideration, intent, and capacity to contract, which I'll look at later in the video. So practically, an offer, okay? I can make you an offer to buy your phone, I can make you an offer to buy your car, you can make me an offer to sell the car, or you can make me an offer to sell your phone. That's just the beginning part of a contract. What exactly do we mean by offers? An offer is an expression of willingness to get into a contract on definite terms, if those terms are accepted. But that is very simple. In reality, things are not always that simple when it comes to contracts. Let's say a relevant government agency in your country says that it's illegal to sell certain pharmaceutical products without the presence of a registered pharmacy. And so you walk into that shop, the drugstore, and you pick these products, put them in the shopping basket, and you walk to the counter. Okay, who's making who an offer? When you're in that counter, who's doing the offer? Is it you? Is it the cashier? Okay? The truth is, you are the one offering to buy. The pharmacist is only offering those goods on display. It's simply displaying the goods, okay, with a price tag. That is not really saying, that is not even making you an offer. That is an invitation to treat. So you are the one who goes there and offers to buy the drugs. So if there is a registered pharmacist present at the counter, then the transaction becomes legal. And you need to understand that, because if you walk into a supermarket, the same thing happens. The supermarket is merely inviting you, okay, to come and pick the goods that you want and then go and make them an offer to buy those goods. Now, these are some of the things that you need to understand. There are kind of rules that govern basic contract formation. So, displaying goods on a shop window, displaying goods on shelves, that is just an invitation to treat. That is not an offer. Aspects like advertisements tend to fall in this category as well, because when you advertise something, right, what are you doing? You're simply telling the buyer that I need you to contact me if you're interested in buying these things, and then buy them. Or I need you to look at the advertisement and make a decision. Do you want to buy? If the answer is yes, then go ahead and buy. In that case, make me an offer to buy, and then I'll accept your offer, and then we have a deal. Now, to understand this, let's look at this case. Khalil v. Carbonic Smoke Ball Company. So here's what happened in that case. The smoke ball company placed an advert in the newspaper stating that it would pay £100 to any of the customers who contracted influenza after having used the product from the company 3 times a day for 2 weeks in accordance with the instruction of the ball. A customer who had bought the product used it according to the instruction and came down with flu and tried to claim the £100 advertised. So if you look at that, you could just say that, well, the company only said that not because they were really making an offer. They were saying that because they were hoping people are going to buy the product. And yes, the company argued that in the court. and they lost. Okay? Why? Here's why. It was pointed out that this was in fact an example of a conditional offer in a unilateral contract. Again, when you make an offer, this is important as part of the risk that's associated with making an offer. When you make an offer that is only binding to you, that is what is going to be a unilateral contract. Here's an example. If you lose your phone and you say that anybody who finds my phone, I'm going to reward them, no one has to look for your phone. But if somebody actually does go ahead and look for your phone and finds it, or it could be your pet cat, okay, and they find your cat and they return it, then you are obliged to actually pay the reward because the contract was only binding to you, but then this person decided to do it, and now you are bound to, to make good of your offer. Before we go any further, you need to understand that there are various kinds of offers. I'm talking about things like conditional offers, cross offers, counter offer, single and standing offer. But then again, nowadays things are changing. For example, if you buy something online or if you buy something from a vending machine, the question becomes, where does this put you in terms of your legal obligations? In fact, in terms of offers, when you buy something from a vending machine, when you buy something from an online shop, who makes the offer at what time and how do they do it? Now, with a vending machine, it's simple because the offer already exists. You see the soda, that's just an offer to sell. You put money, you take the soda, you go. Okay? It is, however, different when you're dealing with online transaction because an online kind of e-commerce platform is pretty much the same as a supermarket, only that it's online. So they are simply inviting you to decide on what you want to buy. And then when you click on the thing, add to cart, it's kind of is the same process you do in the supermarket. So you go to the cashier, aka the cart. Okay? So yeah, that's not an offer. That is more of an invitation to treat. It's one of those things that people tend to argue about, but that is what it is. What this means is that you are the one who's offering to buy. The seller is not selling, but just displaying the goods on the shelf. In this case, the shelf is online, okay? Now, what I want you to understand is that when you're doing business negotiation, you're not going to be saying that, hey, now I'm making you an offer. Okay, you could use that word, but what usually happens is that as you negotiate the terms, as you negotiate what to expect, as you negotiate what you want, in between the process, you make an offer. And so you have to be careful. What exactly are you saying? And whether whatever you're saying is something that can be legally binding, that if they accept, then it might be considered as though they've accepted your offer. So it kind of is just one of those fluid process. It kind of, you get what I'm trying to say. It's not like if you're going to say, okay, ignore everything you've said, now this is the offer. Yeah, sometimes that happens, especially when you're dealing with things like money, where somebody asks you, so how much are you selling it for? And then you say, this is the price, and then that's the last offer I'm making. Yeah, but most of the time, it doesn't work that way. Most of the time, just talk about what you want. Look, I want a website, I want it to be this way, and that way, and that way. And the person asks, anything else? No, this and that and that. And then finally they tell you, okay, so this is what you say you want, that and that and that and that. Yeah, good. So if you do this is how much it's going to cost you. They are making an offer based on your specifications. Okay? So you always have to understand at what point am I in this contract? Because otherwise you risk a lot. You risk making an offer which wasn't really your intention, and then the other party thinks that is the offer, and then you end up having a contract that you got into, which shall later see. Okay. Let's just say you end up getting into a contract that is based on mistake, and mistake is a vitiating factor in a contract. So remember, an offer is not just a question of what to buy or what to sell. Now, in the next class, we shall continue with aspects to do with offer, specifically the counter offer. Because if you make somebody an offer, okay, if you say, let's say the offer is in terms of money and you say 100 and the person says 120. So, the 120 kind of counters the 100. So we shall look at that in the next lesson. I'm Moses, and if you have any question, make sure you ask and we talk about it. I'll see you in the next video.